In the matter of CP 2024-11, Rahamut Enterprises Limited and National Infrastructure Development Company Limited.
Good afternoon, Mr. Chairman, members of the panel. My name is Kerwin Garcia, and I appear for the applicant. With me is Ms. Vishma Singh and Anora Rampasad attorneys as well.
So thank you, Mr. Garcia. We would start with the formal proceedings and we would get into the introductions shortly.
I forgot. Apologize.
That's okay, Mr. Garcia. It's relatively new to most of us here. Good afternoon, everyone. Just to confirm, can the parties confirm that they are hearing me clearly, both the applicant and the respondent's parties?
Yes, please, sir. We can hear you clearly.
Yes, we can.
Thank you very much. Let's get into introductions now. I am David Shallery. I'm presiding as the panel chair today. And to my left is Reverend Joy Abdul Mohan. And to my right is Pastora Brown. We will now go through some formalities in terms of the presence of the parties. Is the applicant or representative of the applicant present? May I have your names, please?
Good afternoon, sir. Kerwin Garcia, attorney at law, counsel for the applicant. With me in this room are Vishma Singh, attorney at law, instructing attorney for the applicant, and Ms. Anora Rampasad, attorney at law, who also appears for the applicant. Joining us by separate feed for the applicant are Ms. Rafia Rahamut, the director, and Ms. Susan Benimado, also a director.
Thank you very much, Mr. Garcia. Is the response? Yes?
Yes, I am Jason Mutu. I appear as counsel for the respondent procuring entity. With me is Mr. Mara Tulsi. We are instructed by Marcel Ferdinand of the firm of Celia and Company. Ms. Ferdinand is on via a separate link. And the representatives of the respondent procuring entity are also on via a separate link, namely the president of NIDCO, Esther Farmer, the manager of procurement and contracts of NIDCO, Laura Ganpat Ali, and Avital Rampasad, legal officer of NIDCO.
Thank you very much, Mr. Mutu. Before we commence today's proceedings, I just want to quickly go through some of the ground rules that will be governing the proceedings today. So first of all, the basic online principles: ensure that you mute your microphone when you are not addressing the panel. Remember to unmute your microphone when it is your turn to speak and speak directly into your device or microphone so that we can hear you clearly. If you have multiple devices in use, please ensure that the others are muted and that you only speak through the main device so that there won't be any feedback on our side. Avoid interrupting a speaker. If you wish to speak while someone is speaking, be it the panel or the other parties, you can use the raise hand feature in Teams, or you may raise your hand so that we can see it through the camera, or you may use the chat function in Teams so that the supporting team can see that you have something to say. Ensure that you are clearly visible during the proceedings so that we can see the participants in the room or rooms where they are. And the parties and or witnesses or participants, we would need to see everyone participating in the room, so they must be visible within the viewing field of the devices and the camera. No unauthorized recording of the proceedings is allowed. The parties can request access to the record of the hearings by filing the prescribed Form 16 if you wish to get the records of the hearing. you can file a Form 16. And finally, in the event that the connection is lost or in any way interrupted during this electronic hearing, you must immediately notify the hearing secretary by calling 226-2477, extension 1161. I would repeat that again, 226-2477, extension 1161, indicating the precise time at which we lost connectivity or there was an interruption. Additionally, you must also confirm that as soon as practicable by emailing to challenge, all lowercase, challenge@opr.org.tt with the case reference number in the subject line and copy that to all other parties in the matter. Do we have any questions on the ground rules before we proceed?
Please, Mr. Chairman, they are clear, we understand them.
Thank you very much, Mr. Garcia. With that being said, now that we have covered the ground rules, we may commence today's proceedings in accordance with Part 5 of the Act to Challenge Proceeding Regulations at Part 10 of the Hearing Rules and Regulations. Our first item on the agenda would be preliminary matters. Are there preliminary matters either side wishes to raise before we move to hear the presentations in this case? I would invite the applicant first.
No, may it please you, Mr. Chairman, none from the applicant.
Respondent, do you have any preliminary issues to raise?
Yes, we filed certain written submissions in reply this morning. I'm not sure whether the panel is in receipt of them, so I would like confirmation that the panel has received them.
We have received the Form 15 in addition to the reply document, response document.
Obliged. Thank you very much.
So at this point, we would proceed with the presentations of the case by the parties in the manner set out in Part 10 of the Hearing Rules and Procedures on Challenge Proceedings. To summarize, we will proceed as follows. The applicant or the representative of the applicant will be invited to make any opening statements. And then after that, the respondent or the representative of the respondent will be invited to make any opening statements. The hearing panel may as well ask any clarification questions based on what was presented. Permit me a brief pause, please.
Mr. Chairman.
And before we continue, I would like to confirm from both the applicant and the respondents on the area of witness statements, where we would have had this discussion on the CMC, but for record keeping purposes, we're just confirming. We would like to confirm whether any witness statements were filed or will be filed. Applicant?
The applicant, thank you, sir. For the applicant, no witness statements were filed as we had agreed.
Thank you. Respondent?
And so too for the respondent.
Thank you, Mr. Mutu. Thank you, Mr. Garcia. So now I invite the applicant to make their opening statement.
Thank you, Mr. Chairman. Mr. Chairman, I'm sure that Mr. Mutu would join me in saying that what the parties propose, with your respectful leave, is to go to Regulation 10.11 of the hearing regulations and to make oral closing submissions to the panel, having regard to the fact that the parties have supplied the panel with written submissions. I'm understanding from Mr. Mutu that there was filed today reply submissions. I, of course, have not yet seen those reply submissions, as I indicated to the panel on the last occasion when we asked for the matter to be put to this afternoon. This morning, we were detained in another place in the Court of Appeal, and therefore we've just come out of that place, and we've not seen those reply submissions. But the understanding has been that the parties would assist the panel with filing principal written submissions, that we would go to the closing submissions today, and that we would thereafter file reply submission. Mr. Mutu has already filed his, and we will file ours on Monday as per the court's order, as per the tribunal's order, I beg your pardon. So if it's all the same to the tribunal and with Mr. Mutu, if it's okay with Mr. Mutu, rather, I think what we rather would do is to address you by way of closing submissions pursuant to Rule 10.11.
Thank you very much, Mr. Garcia. Permit me a brief pause, please.
Certainly, sir.
Thank you very much for that brief pause. Just one housekeeping matter I would like to address. The user avatar Rampasad, all of the participants are not visible on your screen. I'd like to ask the person to my left to move forward so that they can be visible, please. Thank you. Thank you very much. Appreciated. And the user with Ms. Susan Benimado, I'd appreciate if the user to your right could move forward, could move so that we can see them on the screen, please. A little bit more, user Benimado. Yes. Thank you very much. Appreciate it. Mr. Garcia, your comments as far as being able to look at the submitted documents have been noted. At this point in time, the panel would have some questions on the application for review and the reply, which we would like to proceed with first.
Certainly, Mr. Chairman, just to remind panel respectfully that I have not had a chance to look at the reply, but I will not be in a position to answer questions on the reply.
The reply to some respondent would have been the document which would have been filed in May, which we would have had sight of already.
I see Form 9.
Yes, it would refer to the documents that would have been submitted earlier today.
Very grateful. Thank you for the clarification, sir.
Okay, you're welcome. We should proceed with the question. So members of the panel would now like to pose the questions.
Good morning, everyone. Thank you very much to the applicant and to the respondent for all of the information and documentation provided to assist the panel in this matter. I think I just have one question, and that is notice taken in the respondent's response submitted on June the 5th. Reliance was placed on the general guidelines, evaluation of submissions and award of contract in order to confirm that the evaluation would have been conducted in, as stated in Section 10, a procedurally fair manner. Section 14 spoke to the rating on technical ability of the submissions, and Section 15 spoke to the respondents' actions being lawful and fair. So I wondered, since you would have cited the general guidelines, evaluation and of submissions and award of contract, whether you would be able to point, please, to assist the panel in terms of what documentation you may have provided to the panel that would demonstrate the claims made of procedurally fair manner.
I'm sorry, I'm just trying to understand, is this a question directed to both parties, or is it a question directed to the applicant or the respondent?
My apologies, I can clarify. The question is being posed to the respondent.
Okay. Our principal submission on the question of fairness is simply this: that fairness is to be considered in context. And the context is what is required by the regulations, the Act, and the guidelines. There is no free-roaming notion of what is fair or equitable. In fact, if one were to depart from the procedures as prescribed in the guidelines, the Act, or the regulations, that would in fact be unfair. So when the panel has to consider the context or the question as to whether the respondent has acted fairly in relation to the procurement which is now being considered, it must do so applying the criteria as prescribed. That, in short, is our answer to the submission. I'm not sure whether I have anchored my answer directly to what the member has in mind, and if I have not, perhaps I can assist further if additional questions are posed.
Thank you, Mr. Mutu. I appreciate your response, Chair. Would it be okay to repeat the question, probably in brief? Thank you. The question in brief is, will the respondent or can the respondent assist the panel by pointing out any documentary evidence that the evaluation had been completed in a procedurally fair manner? In other words, any document that sets out the procedures followed by the procuring entity during the evaluation proceedings. Are you able to point us to any document, any template, any matrix that would be, any report, anything at all that would be able to assist us, please?
I think I now better understand the question. There is a transcript of what transpired at a post-evaluation meeting where the representatives of the respondent identify for the representatives of the applicant the process which was undertaken. That transcript forms part of the agreed bundle in this case and is attached to the challenge application of the applicant. It is a meeting which was conducted at which representatives of NIDCO, 4 representatives of NIDCO were present, and 4 representatives of the applicant were present. It appears to start at page 90 of the annexures to the respondent's application, challenge application. And it continues to page 124 of that application.
Thank you, Mr. Mutu. Chair, may I have a minute, please?
So, please promise us a brief break so that we may confer.
Certainly.
Certainly, sir.
Like to add to that question as well, because relying on the
Sorry about that. Mr. Mutu, thank you very much for your response.
Perhaps I can just add some clarity, if I may, by saying this. On the case that we have come to meet, no question has been raised as to the absence of any documentary matrix setting out what the evaluation criteria has been. So we have been brought here on very, very narrow grounds. So insofar as any question arises on that, we respectfully submit that it would be manifestly unfair for us to have to answer that in circumstances where the evidence has been closed and the case has been conducted on the limited basis set out in the applicant's challenge. I think it is common ground on both sides as to what NIDCO did and how it did it, as evidenced by the fact that the parties have consensually introduced the post-bid meeting, if I could describe it as that, at which parties, representatives for both parties were present and participated. I just wanted to get that on the record.
Thank you, Mr. Mutu.
Thank you, Mr. Mutu. All right, so we then move in terms of closing. So both parties can file their closing submissions on the 10th of June as previously discussed. So for example, the applicant is to address the points in the reply document that would have been sent today, which they indicated they did not have sufficient time to go through. And additionally, the respondent to confirm the receipt of the Form 15 relating to costs and to give them sufficient time to review that document, and you can file your closing submission on the Monday, the 10th of June.
So if I may,
Yes.
let me not preempt Mr. Garcia and deprive him the opportunity of what he was about to say. I see he's anxious for me to go in front and invoke the ire of the panel. What we understood, and perhaps the error is ours, is that we would be attending today to address the panel orally in respect of the issues that we see arising in the case and how we respectfully consider the panel should rule having regard to the evidence. And while we were conscious of the fact that there was a direction to file further submissions by the 10th, those submissions would essentially be an answer to the principal submissions which the parties had filed just a few days ago, in the event that they weren't able to pick up all the points within a short time frame of addressing the panel today. And perhaps also to raise any questions which might flow from the panel looking at the submissions. We are conscious of the fact that time is very short, and we are given a right under the rules 10.11 to make oral submissions to the panel. So subject, of course, to any directions which the panel wishes to make, we would respectfully like to commend to the panel that it hear the parties orally today in respect of our respective cases. And in the event that the parties wish to supplement anything that they wish to say, they avail themselves of the direction of the panel to file further submissions by the 10th. Because practically speaking, it seems to me, if memory serves me correctly, because of the short time frame, I believe the panel has to deliver its decision by the 14th. I don't know how we can properly accommodate an oral hearing between the 10th and the 14th to do justice to the case and best assist the panel. Those are my submissions.
Okay, thank you, Mr. Mutu. Mr. Garcia, are you concurrent with that opinion?
Yes, please, Mr. Chairman. We certainly, that is to say, Mr. Mutu and I, because of the fact that we operate usually in a different sphere, that is to say, in the Supreme Court. Ordinarily, in the Supreme Court, what would happen is that parties would file written submissions, and then the panel or the court would call the parties before it to amplify or to explain or to emphasize certain aspects of their written submissions. So that was the basis upon which Mr. Mutu and I thought that we would be assisting the panel. However, as we have said all the time during the course of these proceedings, these challenge proceedings, I think the parties need to do whatever the panel requires the parties to do for the panel to be assisted. So it's not for us to say we have a right to address the panel. It is really for the panel to say whether they want to hear us or not. For example, there is flexibility in the regulations, the hearing regulations, Regulation 3.3. The hearing panel may, by order and on terms, extend or abridge any time period fixed by these rules. And generally, we rather feel that the panel, it is up to the panel to tell us how the panel wishes to be assisted. If the panel, for example, sometimes in the High Court as well, the parties file submissions, fix a date for oral submissions, but because the written submissions are so helpful, the High Court might say, well, I don't need to hear you. I can read for myself, thank you very much, no need to hear you. So if that is the position that the panel feels will assist it best, we are happy to be flexible and to pivot towards that position. But we do agree with Mr. Mutu that we came into this hearing today on a different understanding, and that is entirely as a result of our innocence in these forum. This is a new forum for us, and we are learning as we go along. We are innocent of the normal practices of hearing panels. At least I am, and therefore we meant no disrespect when we agreed between ourselves that this was the way we thought we could assist you best. But if it is that the panel is saying that there is another way that they can be better assisted, we are prepared to go with that. So it's entirely up to the panel in our respectful submission at the end of the day, whether the panel wants to hear from us orally now, or whether the panel wants to say, well, go ahead and file your final written closing submissions on Monday, and we will take it from there. Those are our submissions, please.
Thank you, Mr. Mutu. I'm sorry, thank you, Mr. Garcia. I see Mr. Mutu has raised his hand. I recognize Mr. Mutu and team.
Oh, could I just before Mr. Mutu replies, this might assist as well, say one more thing. Regulation 4.8. The hearing panel may regulate its own procedure and shall conduct the hearing fairly. So if it is that the hearing panel determines that this hearing can be conducted fairly in the way that involves us simply filing written submissions and the panel dealing with the written submissions and arriving at its determination, that's fine with us. What we say is that you do have the power to determine your own procedure. Thank you.
Thank you, Mr. Garcia. Mr. Mutu, I recognize you.
Yes, thank you. I have a slightly more robust position than that of Mr. Garcia. And that I do, while I accept that the hearing panel may regulate its own procedure and shall conduct the hearing fairly. Prior to coming here today, there was no indication that there would be a departure, and may I also say, in preparing our written submissions, there was no indication that there would be a departure from hearing rule 1011, which is couched in mandatory terms, in that the parties shall be allowed to make oral closing submissions. So it is on that basis, and the fact that there was no attempt to abrogate the operation of this rule, that we filed our submissions in the full expectation that we would be making oral submissions. Might I say this as well? I certainly can't speak for the applicant, but for the respondent, the decision that this panel makes in relation to this challenge can and is likely to have far-reaching consequences generally on the RFQ process. This panel, as far as we are aware, will be the first panel that is dealing with some of the issues which we have raised here. And because of the principle of judicial consistency, it is our expectation that the decision made by this panel will be followed by subsequent panels insofar as is possible. We are breaking new ground having regard to the provisions of the Procurement Act. And in our respectful view, it is extraordinarily important at the very early stages to get things right, to give the panel the best assistance that it can, and given the compressed time frame within which panels have to make decisions, we think it incumbent on us to assist the panel orally in our submissions. We are not content, and I say so with the greatest respect, we are not content merely to rest on the written submissions. As we all know, and this case is perhaps demonstrative of the fact that language can be interpreted in a number of ways. And when the panel sits to read the submissions and understand the submissions, the panel needs assistance or may need assistance. And that clarity can be provided in no better forum than today, and by no better means than counsel for the respective parties addressing the panel. And that is my submission in relation to the issue as to whether we ought to be given an oral opportunity to assist.
Thank you, Mr. Mutu, and we are indeed breaking new ground. Before we take a short break for the panel to discuss, Mr. Garcia, I saw you had your hand up. Do you still wish to speak?
Yes, may it please you, Mr. Chairman. It is not often that I depart from my learned friend, Mr. Mutu's analysis. But on this occasion, I feel duty bound to do so and to point out to the panel, Rule 4.11. The panel may waive any of these rules. That's what 4.11 says. So it is not accurate to say that the parties have a right to insist upon an oral hearing, because that is subject to the panel's overriding power in Regulation 4.11 to waive or vary any of these rules in respect of any challenge proceedings, whether groundbreaking, whether historic, first time or not. Any challenge proceedings, if the panel is of the opinion, not if Mr. Mutu is of the opinion or Kerwin Garcia is of the opinion, if the panel is of the opinion that to do so would be in the public interest or would be otherwise advisable to secure the just and expeditious determination of the dispute. And Mr. Mutu helpfully spoke about compressed timelines. It makes sense if the panel were to determine to waive the rule that there be oral submissions because there is a compressed timeline and in the interest of the proceedings being expeditiously determined, the panel were to choose to do so. So it is not a question of your having no jurisdiction or no discretion rather, and the lawyers who appear for you or the parties or their representatives who appear before you having a right. I think that is putting it too highly, with greatest respect to my learned friend, because you have the power to waive it. And what we say finally is that, we might want to assist you, but you have to tell us how you want to be assisted. We can't insist that you must be assisted in the way that we want. You are the ones who have to make the determination. And if it is therefore entirely up to you to tell us how it is you want to be assisted. And we just point out again Regulation 4.11, and we say to you that whichever decision you make in your discretion, and that's what 4.11 gives you, a discretion, we are willing to help. We are here. We are willing to help in any way that you decide you need help from us from. Much obliged.
Thank you, Mr. Garcia. Before I give you the floor, Mr. Mutu, please know that there will be a very short, I'll give you a very short time to respond, following which the panel will take a very short break to discuss the points made by both senior counsels, and we will discuss and get back to you shortly. Mr. Mutu?
Thank you. In the event that I didn't make myself clear, but I think I did, I never said that the panel was ousted from making a decision that wouldn't allow the parties to address them orally. I said that the language of the rule was mandatory, that the hearing so far was conducted without any abrogation of that rule or any waiver. If there's to be any waiver of any right, for that to be fair, the parties must be given adequate notice. It can't be that we turn up and we learn of this on the day of the hearing. Now, the respondent is not afraid of oral hearing. The respondent would like to avail itself of the opportunity. And what is very important here, I've heard what Mr. Garcia has said, but what he has not said is that under these rules, there are specific requirements for written hearings. In fact, they are quite extensive. And under Rule 11.4, the panel has to, not 4.11, but 11.4, the panel has to decide whether to hold a written hearing, and if not, it will take certain matters into account. 11.5 says the hearing panel will not hold a written hearing if a party satisfies the panel that there's good reason for not doing so. So with respect, the onus is the other way. The inescapable inference is you will have an oral hearing unless there's good reason not to have one. So insofar as the applicant contends otherwise, and that these proceedings should be truncated and effectively shut down to a written hearing only, we respectfully disagree. We are here to be transparent, to be open, to assist, to interrogate the issues, and to get to the bottom of the applicant's challenge, which we say is entirely unmeritorious. And if you give us an opportunity to address you orally, we intend to show you why. Thank you.
Thank you, Mr. Mutu. At this juncture, the panel will be taking a short break to confer on all the points raised, and we will get back to you shortly.
Thank you, sir. Much obliged.
Thank you very much for that, of permitting us that short break. The panel has conferred, sorry. We have discussed the points raised by both parties, and we have determined that we would proceed with the oral submissions.
Very grateful, sir. Much obliged.
In light of that, though, Mr. Garcia, notwithstanding the documents that you would not have had sight of that were filed this morning, you are still prepared to proceed?
Yes, what I can do is, sorry, sir, please go ahead. I apologize.
Yes, and any thing that you would like to file in terms of what you see in those documents today, you can file it on the documents to be finally submitted on the 10th.
Precisely, yes, please, sir. Precisely. Much obliged.
Okay, so we would proceed with the oral submissions. The panel is recommending 45 minutes per party.
That is more than sufficient for our side. I'm sure it is for Mr. Mutu as well.
Mr. Mutu? Mr. Mutu, would the 45 minutes recommendation be suitable to you and your party?
Well, I would try to keep within that time frame. If I'm beginning to veer outside of it, I will let you know. But a lot may depend on the concessions Mr. Garcia has to make.
Okay, thank you very much, Mr. Mutu. So we may now proceed with the oral submissions. I would invite the applicant to make his oral submissions, following which, if necessary, the panel may take a short break, and then we would proceed with the respondents' written submissions. So, Mr. Garcia, the floor is yours. You may proceed with your oral submissions.
Thank you. Thank you very much, Mr. Chairman, members of the panel.
Proceed.
Thank you very much, Mr. Chairman and members of the panel. Just tease Mr. Mutu and say thank you, Mr. Mutu, for the opportunity that I have to address the panel this afternoon. We propose to use our time together, please, sir, to do two things. First, to summarize what, in essence, the parties have said in their respective written submissions, putting aside the fact that I am not able to assist at the moment on the reply submissions filed by my learned friend. And the second thing that we want to spend time doing in the 45 minutes allotted, please, sir, is to run through some of the paragraphs, some of the material in the respondents, I'll now call them principal submissions, and state what our responses are to some of the matters that are stated there. So if we can begin with a summary of the respective principal submissions that the parties have shared with the panel so far. Members of the panel, the appellant's case is simple. We say that the evaluation criteria and evaluation methodology for assessing submissions must be set out in the solicitation or bidding documents. That's our case. And in this case, of course, as we all know, the solicitation or bidding documents constitute the RFQ. The respondent's case, as far as we can tell, we haven't read the reply submissions yet, but as far as we can tell from the principal submissions by the respondent, is far from simple. The respondent says that the RFQ is merely a starting point. See the respondent submissions at paragraph 8, line 4, and that the RFQ has to be read in the context of the purpose of an RFQ, having regard to relevant provisions of the Act, together with the applicable guidelines. And you see that said by the respondent in their principal submissions at paragraph 8, lines 4 to 8. But respectfully, that's a lot of legalese. But what all of that legalese we say boils down to is that the respondent is saying that a supplier has to make connections between the Act made by Parliament, multiple layers of rules made by the Minister, and multiple layers of guidelines made by the Office of Procurement Regulation. And with your permission, please, members of the panel, for speed, permit me to refer to the Office of Procurement Regulation as the OPR in the course of these submissions. What it is the respondent is saying is that a supplier has to make connections between the Act, the rules, and the OPR guidelines, and carrying all of these on its back, cut its way through a jungle of case law, and then put all of these interrelated elements together in order to find out what the evaluation criteria and what the evaluation methodology really are. And if a supplier can't do that, too bad for the supplier. We say with respect that the respondent's approach is wrong. We say that the burden is on the procuring entity to set out its evaluation criteria and methodology, not on the supplier to pick up a torchlight and go searching through a legal maze in order to find it. We say that the Act and the regulations and the guides are there to guide a procuring entity as to how it must structure its solicitation documents. But the Act and the regulations and the guidelines are not the solicitation documents themselves. The Act and the regulations and the guidelines all make it clear that a procuring entity must put the whole of its evaluation criteria and the whole of its evaluation methodology into what? The solicitation documents. A procuring entity cannot fail to do so and then say to a supplier, well, you were supposed to figure out what I didn't put into my solicitation documents by going through the Act and the regulations and the guidelines. You'll find the answer there. That's not transparency. Having said that, we can deal now with why we say the respondent submissions in many parts actually support the case for the applicant, and we will deal very briefly with some of the paragraphs in the respondent submissions to which we'd like to put our position. So if you could ask the panel to please look with us at the respondent submissions, that's the principal submissions. And if we could start with page 1A, introduction. So that's introduction at page 1, capital A. Part of the introduction is paragraph 8, to which I referred earlier. And paragraph 8 says, in our respectful submission, and as we demonstrate below, Rahamut's framing of the issue in this way is specious and adopts an approach which is unduly literal, simplistic, and unsupported by legal authority. Lots of legalese. While consideration of the terms of the subject RFQ undoubtedly forms part. So the strategy in the submissions is to say, well, the RFQ is a small part. Don't worry too much about the RFQ. Let's find the terms. Let's find the evaluation criteria. Let's find the evaluation methodology elsewhere. Don't worry too much about the RFQ. Don't let that trouble you too much, members of the panel. It is merely the starting point, and that's the point I made earlier when I was summarizing in essence what the parties' respective cases are. And they go on to say the meaning of the subject RFQ must be considered in the context of the purpose of an RFQ, having regard to the relevant provisions of the Act together with the applicable guidelines and regulations. If I can ask you to look very quickly then at page 3B, general principles.
Mr. Garcia,
Just
Mr. Garcia,
yes, sir.
permit me to interrupt you shortly. You will get back your time.
Of course.
We are we just want to make sure that we are on the same page. So giving members of the panel time to get the document that you're referring to, that so we can all refer to the same documentation and guidelines.
Certainly, sir.
Mr. Garcia, thank you very much for bearing with me. What we have done is that we are sharing the document to which you are referring to both enable the panel to keep up and as well as the other participants can refer to the documents and the sections to which you are quoting. You will be given your time that you have lost while we were preparing, and you
Thank
may
you.
proceed as soon as you are ready.
I might need to claim a little extra time for the reason that these appear to be the reply submissions that were filed today. And the document to which I'm referring are the principal submissions that were filed on the 5th of June.
Yes. We would be putting up the principal documentation. Apologies for that, Mr. Garcia.
Not at all, sir. Shall I proceed or shall I wait for that to happen?
Let's wait for it to be on screen so that all parties would be on the same page, literally.
Yes. Thank you, sir.
Mr. Garcia, the document is now on screen. You may proceed.
Thank you so much, sir. Much obliged. So I was about to ask the panel to go with me to paragraph 13 under part B, general principles, paragraph 15. That's on page 5. And you will see it said there, members of the panel, that the role of the panel is not to interpret what is included in the subject RFQ on the narrow basis of the contents of one sentence alone. That, we say, is no doubt an attempt by the respondent to escape the consequences of the one sentence alone in the RFQ, which sets out the evaluation criteria, and which, of course, reads, quotations will be evaluated at the sole discretion of NIDCO based on what? Quality, price, and availability. And we invite you to hold the respondent to its words, and members of the panel, and not as the respondent is inviting you to do, to devalue the significance of that one sentence alone. What is the passage that we read about in another place? The stone that the builder rejected has become the cornerstone. We say that that one sentence alone is the cornerstone of this matter. Could I ask you please to go to page 6, C, the relevant law. And you see that the respondent says there at paragraph 15 of its submissions, against that background, we now turn to consider the relevant statutory provisions, and the statutory provisions are discussed in the paragraphs that follow. What are also discussed in the paragraphs that follow, Mr. Chairman, members of the panel, are some of the regulations published pursuant to the Act and some of the guidelines published by the OPR. Now, we say that is all well and good, but that the relevant statutory provisions are not the solicitation documents themselves, and that a procuring entity's evaluation criteria and evaluation methodology have to be set out in the solicitation documents themselves. It cannot be otherwise. If a procuring entity is asking suppliers to tender or to make a submission, there are two duties that are cast on the procuring entity. First, to state clearly what the service or the goods that the invitation is the subject of are. And the second obligation is to say how those submissions are going to be evaluated. What is the methodology? What is the process? And what are the criteria? You have to say that in your solicitation documents. At paragraph 18, if I could invite your attention to that paragraph. the respondent raps us on the knuckles and says that we mistakenly refer to the provisions of the OPR's evaluation guidelines as a clause, but that the correct term is a section. We accept that and we apologize. But in the fifth line of paragraph 18, the respondent refers to section 2 of the evaluation guidelines and quotes what it says. What it says are the material parts. And we respectfully invite the panel to pay particular attention to the parts of section 2 that the respondent itself quotes there and that the respondent itself says are the material parts. The parts that the respondent says are material read, it is a legal requirement to define the evaluation process, that is evaluation methodology, the process by which the procuring entity is doing its evaluation. It is a legal requirement. They say that this is the important part. It is a legal requirement to define the evaluation process in summary form where? In the bidding documents. That's where they have to be defined, in the bidding documents. They go on, the major categories on which the bid or proposal will be evaluated and the weight to be assigned to each factor should also be identified in parentheses in the bidding documents. That's the only construction to give there. Because the next sentence is the bidding documents, not the guidelines, not the act, not the regulations, your own bidding documents should explain the criteria that can or will result in the rejection of an offer, affirm that the evaluation will include the price, and state the relative importance of each major selection evaluation criteria. All of this information has to be set out in the bidding documents themselves. The guidelines do not say that that information can be left out of the bidding documents and that suppliers can be directed to the Act, the regulations, and the guidelines to find out what that information is. That's not how procurement is to be done. Then the respondent emphasizes, you see it in bold print on the screen, the following words. The procuring entity shall conduct a preliminary examination of the submissions to check compliance with the terms and conditions and the mandatory criteria set in the bidding documents. The mandatory criteria set in the bidding documents. The remaining substantially responsive submissions will then be evaluated against all the criteria set in the bidding documents to determine the successful supplier or contractor. So they've emphasized this, and what this is telling us is that you must evaluate a submission against the criteria set in the bidding documents. And that if you have mandatory criteria, you don't point to a regulation or point to a guideline or point to the Act. You set it out in the bidding document. What the respondent says that it did, and we will see this when we come to paragraph 29E as an egg, and paragraph 32 of the respondent submissions, what the respondent says that it did was adopt an evaluation methodology in which submissions were checked for compliance with certain mandatory requirements, which bidders were required to satisfy, then assess such compliance on a pass or fail basis, and then move on to assess only price. That's what they say there, 29E and 32, will come to it. Now, the first point we make about what the respondent says it did is that that evaluation methodology appears nowhere in the RFQ in this case. It appears nowhere in the solicitation documents in this case. The respondent was free to apply in any evaluation process that it chose. But as section 2 of the evaluation guidelines referred to by the respondent at paragraph 18 makes clear, that process had to be defined in summary form in the bidding documents. What the respondent did, please members of the panel, was keep that evaluation process that they described in paragraph 29E and paragraph 32. What they did was to keep that evaluation process secret. They didn't tell anybody that was what they were going to do in their bidding documents. And then apply it without having told suppliers upfront in the bidding documents, in the RFQ, what the evaluation process was going to be. As we will explain a little later, the respondent also did not specify which of the technical requirements in the RFQ were mandatory and which were not mandatory. We'll come to that. If you could invite the panel to look next at paragraph 20 of the respondent submissions. That's at the bottom of page 21. There, the respondent refers to clause 3.7. It should, of course, be section 3.7 of the evaluation guidelines and puts in bold print for emphasis some of the words in the last paragraph quoted there. The highlighted words are the last paragraph over on page 10. The highlighted words are: the contract is awarded to the supplier or contractor with the highest combined score, except in the case of least cost selection. Now, I pause here to respond very briefly to the discussion that was had between Member Brown and Mr. Mutu a little earlier. The question that was asked, let's put it in respondent. Has the respondent disclosed its evaluation documents, its evaluation report? Has the respondent disclosed its working papers as it was sifting through the evaluation? And the answer is that the respondent has never disclosed that to the applicant. And I think that was Member Brown's question. Are there any documents by which the evaluation process that is set up in compliance with the Act and the regulations and the guidelines and, importantly, the bidding documents, most importantly, the bidding documents, are there any documents in these challenge proceedings by which the respondent intends to demonstrate such compliance? So when the respondent puts in bold print with the highest combined score, except in the case of a least cost selection, what highest combined score? Combined scores of what? That has not been disclosed at any time to the applicant. So we say that nowhere in the solicitation documents did the respondent ever say in the first place that submissions were to be assessed on a least cost basis. They never said that. The respondent could have done that, Mr. Chairman and members of the panel. It's up to the supplier to say how it wants its bids to come in and what are the factors it's going to use to evaluate those bids and what is the process it's going to use to evaluate those bids. Just as we respectfully submit, it's up to the tribunal to tell us how it wants to be assisted. But the point is that you have to put those things in the bidding documents, in the solicitation documents. If you want to go on a least cost basis, that had to be stated in the solicitation documents. That was not stated. And before we leave that quotation, can we please direct respectfully the panel's attention to the third to last paragraph of the quotation? That is to say, the passage after the first arrow. You will see there we have it, that the guidelines say technical stroke qualifications proposals that fail to meet the relevant minimum requirements specified in the bidding document shall be considered non-responsive and shall be rejected on that ground. We make the same point over and over. And forgive us if we sound like a broken record. That's why we say our case is very simple. Show me it in the solicitation documents. Show it to me. Nowhere in the solicitation documents did the respondent set out minimum technical qualifications and requirements. Can we ask the tribunal, please, to look next at paragraph 26 of the respondent submissions? And you'll see there that the respondent quotes from paragraph 3.2 of the evaluation guidelines and highlights certain words. In the second paragraph of the quotation, just above the table, the words highlighted are: the procuring entity must decide which criteria will be mandatory and which will be weighted. So we make two observations about that, please, members of the panel. First, we say that that is obviously information which the procuring entity cannot keep a secret. That is vital information which the procuring entity has to disclose in the solicitation documents. And we say second, that nowhere in the RFQ in this case does the respondent disclose that information. On the second arrow, over the page 15 now, the respondent highlights the words: price factors may be used solely or together with non-price factors. No problem, but you have to tell us. You have to tell us. And we say that plainly in this procurement exercise, the respondent stated price factors and non-price factors, availability and quality, as the criteria for evaluation of the submissions. The respondent did not say that price factors would be used solely to evaluate submissions. So when my learned friends highlight price factors may be used solely, we don't disagree, but you have to say so. If you could invite the panel to look next at paragraph 29 of the respondent submissions. At paragraph 29A, the respondent says, first, the nature of an RFQ was made clear by regulations 10 and 11 of the Methods and Procedures Regulations, and paragraph 7.2.1 of the Methods and Procedures Guidelines is a quick, low-cost means by which a procuring entity seeks to solicit prices and basic terms and conditions for the provision of goods and services. The reasonably well-informed and normally diligent tenderer would understand as such. We'll make two comments about that paragraph. First, it does not follow, and I hope that the respondent is not suggesting, that because an RFQ is designed to be a quick, low-cost mechanism, that gives the procuring entity a license to be unfair. That because it is quick and low cost, you don't have to follow the procurement guidelines. You don't have to put your evaluation methodology. You don't have to put your evaluation criteria in the bidding documents because it's quick and low cost. Just like that one single sentence. Don't worry about it. RFQs are an exception to the general rule, you know. This is fast, quick money. So turn your eye the other way, turn in the other direction. We say that is not the law. RFQ or fancy invitations to tender, same principles of integrity apply. And the second comment we make is that what the reasonably well-informed and normally diligent tenderer, to use my learned friend's words, what that person would understand is what is stated in plain English in the RFQ. And in this case, the reasonably well-informed and normally diligent tenderer would understand that its submission would be evaluated, as the RFQ says in that single one sentence, on the basis of price, availability, and quality. That's what the reasonably well-informed and normally diligent tenderer would understand. At paragraph 29B, the respondent says, second, Regulation 5.1 of the Evaluation Regulations and paragraph 3.2 of the Evaluation Guidelines recognize that price factors, as compared to non-price factors, may be used solely in evaluating submissions. There is no obligation on a procuring entity to evaluate a submission by reference to non-price factors. Well, we agree that where price factors are stated in the solicitation documents to be the sole factor, there is no obligation on a procuring entity to evaluate a submission by reference to non-price factors. But if, as here, the procuring entity includes non-price factors in addition to price, and tell suppliers that quotations will be evaluated based on quality, price, and availability, the procuring entity has to do what it said it would do. And it has to evaluate the submissions based on the criteria, the evaluated criteria that the procuring entity sets out in its solicitation document. The procuring entity can't say to a supplier, here are the criteria to be used, and then say to them, but we catch you. Because the regulations say we don't have to use the criteria we promise you we will use. Can't say that. At paragraph 29E, the respondent says, fifth, in compliance with regulation 11.3 of the methods and procedures regulations and paragraph 7.2.3b of the methods and procedures guidelines, the subject RFQ did set out certain mandatory requirements which bidders were required to satisfy, aimed at ensuring the existence of basic requirements to provide the requested services with respect to inter alia, quality, and availability. So, like our great West Indian cricketers of the 70s and 80s are doing, they're swinging the ball from side to side. 1 minute, we have to consider non-price factors. Other minute, we're considering non-price factors. They're there. That is not integrity. That is not transparency. Tell us what you're going to do, and then tell us, as Member Brown has inquired, how you did it. Tell us what you're going to do it, and then tell us how you did it. We respond to this paragraph by saying that the RFQ does not say what are the certain mandatory technical requirements as opposed to non-mandatory technical requirements. The scope of works simply lists technical requirements without separating out which certain ones are mandatory and which certain ones are non-mandatory. It can't be right, members of the panel, for the respondent to say that all was mandatory, everything was mandatory. Because the solicitation documents don't say that, first of all. And because, you know what, as they say in the boardrooms, if everything is important, then nothing is important. So everything can be mandatory. Can we invite the panel to look next at paragraph 31 of the respondent submission? There the respondents say that in any event, contrary to Rahamut's contention, NIDCO was precluded by regulations 3 and 5.5 of the evaluation regulations from using a and or any weighting or scoring system in respect of non-price factors for the evaluation of bids, as no such weighting or scoring system formed part of the subject RFQ and or was disclosed to the bidder. So they know very well when they're not disclosing things to the bidders. We respectfully disagree with paragraph 51. Regulations 3 and 5.5 of the regulations say no such thing. They contain no such prescription. They contain no such prohibition. Regulation 3 and Regulation 5 are conveniently quoted in the respondent submissions at pages 13 and 14. So if you could ask me to go back to those pages, 13 and 14. Mr. Chairman, members of the panel, you will see that at page 13, the quote from Regulation 3, look at Regulation 3.3. An evaluation criterion may refer to both price and non-price factors. It does not say that a procuring entity is precluded from using a and or any weighting or scoring system in respect of non-price factors for the evaluation of bids. Look at Regulation 5.1 at the bottom third of page 13. It says a procuring entity may identify in its bidding document, in addition to the price factor, the relevant non-price factor and method of application, which may be considered in evaluating a submission in order to determine the proposed best value for money submission. That too does not say that a procuring entity is precluded from using a and or any weighting or scoring system in respect of non-price factors for the evaluation of bids. In fact, turn over the page. Regulation 5.4 on page 14 expressly says the opposite thing. It does not say in Regulation 5.4 on page 14 that a procuring entity is precluded from using a or any weighting or scoring system in respect of non-price factors for the evaluation of bids. It expressly says a non-price factor shall be prioritized, assigned merit points, and weighted according to its relative importance in meeting the desired outcome of the procurement. So respectfully, we say that the regulations in fact state the opposite of what the respondents say they say in paragraph 31. Can we come back to paragraph 31 again of the respondent submissions? And in the second sentence of paragraph 31, no, I'm sorry, paragraph 32. Paragraph 32. In the second sentence of paragraph 32, the respondent says this is precisely what is contemplated, if not mandated, by paragraph 7.2.3d of the Methods and Procedures Guidelines, which stipulates that the successful quotation in an RFQ process shall be the lowest price quotation meeting the needs of the procuring entity as set out in the RFQ. My learned friends, in their principal written submissions, refer to a famous quotation by a famous House of Lords judge by the name of Lord Stay. In law, context is everything. In procurement too. And in response, we say that the guidelines cannot be used to relieve the procuring entity of a clear promise that it has made in its solicitation documents as to the criteria to be used to evaluate a supplier's submission. That is the context. You can't point to something outside of the document that says what it says and say, but we catch you because the guidelines say we don't have to use what we tell you we're going to use. And lastly, I'm going to end very shortly. Can we ask the panel to please look at paragraph 35 of the respondent submissions? This has to do with the point about one or more than one road tank wagons of a particular capacity, in this case 50,000 liters. And you will see that the respondent says there in paragraph 35, further, applying the principles of interpretation in healthcare at home and RED Electronics Inc., we submit that there is nothing either expressed or implied in the subject RFQ that a contractor was required to have a single or more than one RTW with an individual capacity of 50,000 liters. Our response to that submission is simple. The respondent did in fact expressly tell the applicant in an email sent on March 14, 2024, that is attached as part of Exhibit C to the respondent's Form 9, please confirm if your company is in possession of a single truck with RTW of 50,000 liter capacity. And perhaps to end, you should just look at that particular email in its full context. That is, as I say, please, Mr. Chairman, members of the panel, an email attached to Exhibit C, to the back of Exhibit C, to the respondent's reply, the respondent's Form 9. I'm just pausing so to anticipate that the panel would want to put it up. I'm guessing. Please correct me if I'm wrong.
That's correct, Mr. Garcia.
Thank you so much. If you could go to the last, come down to the last page. Okay, very grateful. So if you could go back, so that's the end of the email. If you could go back to the top. Just go up a little bit. Yes, right there. So that's from Andrea Williams at NIDCO.co.tt, sent on the 14th of March at 12:03. And it's sent to a number of persons. including Petroleum Distributor Services Limited. And it is said there, good day, subsequent to the issue of the caption RFQ and receipt of your proposal, the following requires clarification. So this is the procuring entity on its own volition, engaging in post-bid clarification and saying, a little lower down, in response to the technical requirement item 4, provision of suitably certified road tank wagon of 50,000 litre capacity, you stated in your proposal that for the purpose of bunkering so and so and so, REL will make available its 50,000 litres RTWs to transport and pump diesel fuel as per NIDCO's bunker schedule requirements. And then what NIDCO says is, please confirm if your company is in possession of a single truck with the RTW of 50,000 litre capacity. Please confirm that your truck has the necessary capability to transfer the fuel directly from truck to vessel. And you will see that there was an answer to that. If you go up a little higher. From Mahendra Sinha, sent to Andrea Williams on Thursday, March 14, 2024 at 12:29 and 46 seconds p.m. Your email query was received. Kindly see your response hereunder. I'm sorry. We hold on to. It's if you go back to where we were and we just go up one page, there you are. So yes. Go up one more page. Good. There you are. Rahamut Industries Limited is confirming that we are in possession of 3 road tank wagons, each with 50,000 litres capacity. So we say that it was made clear, it was made express, that what was required by way of the technical requirements was a single truck with RTW of 50,000 litre capacities or more than one single truck with that capacity. So for all of these reasons, Mr. Chairman, members of the panel, and for all of the reasons set out in our written submissions, we respectfully ask the panel to grant the application and to grant the applicant the relief set out in the applicant's Form 8. And those would be the oral submissions by way of further assistance that we feel able to give you at this time. I'm much obliged.
Thank you very much, Mr. Garcia, for your submission. The panel will take a brief break, following which we would listen to the submissions from the respondent. Respondent, I would like to ask you if you are relying on any documentation that you would like us to put up on the screen. If you can indicate so in the chat so that we may prepare ourselves when you begin your submission. So you can send it in the chat and we will ask the support team to have those documentation ready. And you may do so while we are conferring for the next 5 minutes or less.
I'm obliged.
Thank you, Mr. Mutu. We will now be proceeding on a short break. Hi, good afternoon, everyone again. Once again, Mr. Mutu, you may now proceed with your submission. We have taken note of the documents that you requested, and when you are ready, the support team will have it available on the screen so that the parties may refer to it. The floor is yours.
Thank you, Chairman. Mr. Garcia is right. Our position in this matter is that context is everything. So when the panel comes to consider the challenge before it, context is going to be one of the key matters, if not the dominant matter, that the panel must consider. What is this challenge about? Well, we submit for a contract, the Petroleum Distribution Supplies Limited. For what? For the transportation and pumping of diesel fuel. The NIDCO's port vessels over a 2-year period commencing May 2020. And it is an attempt to prevent NIDCO from awarding this contract for what in public sector terms is a relatively modest sum of money of $3.227 billion. Now, of course, it is also important to note that it's Rahamut's attempt to prevent its competitor from gaining a contract. Now, Rahamut's case is essentially that it wishes to have the bid declared as non-compliant. That is the bid of its competitor for failure to meet technical requirements. As we will come to in the course of NIDCO's submissions, the panel will recall that the applicant has drawn reference to the road tank wagons and the appropriate capacity. It essentially wants to say it was the only entity that met these requirements. Because remember, this is a 2-horse race. It is Rahamut or PDSL who must emerge as the victor. Rahamut wants this panel, and it is clear from its application, from its challenge application, to have the bid re-evaluated. And one asks why? Well, the answer is self-evident. Because if the only competitor is declared non-compliant, Rahamut walks away with the contract for the price of $3.787 million. That is a price that is 17.4%, we can do the math, greater than the current award. Converted to dollars, it's $560,571, over $500,000 more than the award that NIDCO intends to make or intended to make, but for these challenge proceedings. And this is a challenge in the context of a RFQ process, the outcome of which, and we will come to it in a moment, is driven largely by price considerations. The regulations tell us that, the guidelines tell us that. But Rahamut says, look, the lowest tenderer, forget him. You see me? Give it to me for 17% more than the actual price and keep our competitor out in the cold. Now, of course, the irony is they say on the one hand, reevaluate our bid. But on the other hand, they say nobody knows what the criteria is, but they still want the contract. So reevaluate it in accordance with what requirements? What that reveals is that it reveals an anxious consideration by a competitor to hold on to a contract. Pursuant, it's so desperate to hold on to the contract that it is prepared to say, give it to us in circumstances where we impugn the RFQ process. Because their submission is, and Mr. Garcia just took us there, you have evaluation criteria in secret. You have it in a cupboard somewhere that nobody else can see it. But reevaluate our bid. According to what? According to what? Now, I adverted to this earlier on when we were dealing with the question as to whether this should be an oral hearing or not. And I wish simply to restate the point that the decision that this panel makes in our respectful submission is will be a very important, because it will chart the course for the manner in which challenges the RFQ tenders or bids are dealt with by procuring entities. But we say, even though the applicant says to the contrary, we say that this RFQ process, which the panel has to consider, is governed by 4 key documents. One, well, apart from the RFQ itself, one, the public procurement and disposal of public property regulations. Methods and procedures regulations, forgive me. Those are regulations made under Section 63 of the Act, and in particular, regulations 10 and 11. I'm not going to invite the panel to look at these regulations now in the interest of time. I will come to select portions later in the course of my submissions. So there's no need to bring it up on the screen.
Yes, I did.
The other document we see is the public procurement and disposal of public property evaluation regulations, particular regulations 3 and 5. The third document we see, which is of significant consideration and import, are the general guidelines for procurement methods and procedures issued by the Office of Procurement Regulation pursuant to Section 31 of the Act, and in particular, paragraphs 3.1.3 and 7.2. And finally, the fifth document, apart from the RFQ itself, is the general guidelines for the evaluation of submissions and award of contracts issued by the Office of Procurement Regulation under the same section, and we see that the relevant portion that will engage the panel here is paragraph 3.2 of that document. Now, at the outset, we submit, for the reasons which I will develop in due course, that NIDCO's decision to award a contract to Rahamut's competitor, PDSL, for the transportation and pumping of fuel to NIDCO's port vessels was lawful, fair, and done in accordance with the law as laid down by the Act, the regulations, and the term of the RFQ, once they are properly construed. We also say that if there were any ambiguities in the RFQ, which we don't accept, but if the panel finds that there are any ambiguities, Rahamut's conduct in participating in the RFQ process in the way it did is such that it cannot now belatedly complain in these challenge proceedings in relation to these unbelief. And for those broad reasons, we say Rahamut's challenge application should be dismissed. Now, when Mr. Garcia began, I listened to him with great interest, because it appeared to me that what he was inviting the panel to do is adopt an extraordinarily myopic approach and look merely at the RFQ document itself in isolation, outside of context. Now, we say two things about that. The first submission we make, and will be made good when we come to examine the RFQ itself. The first submission we make is that the evaluation criteria was contained in the RFQ document. It was not secret. And when one examines that document, you will see it is there. It is only secret to those who are willfully blind. But without prejudice to that submission, separate and apart from it, the applicant says, disregard the regulations, disregard the guidelines. As we say locally, they say, don't worry about that. Look only at the RFQ. But there is a small problem about that. The problem that the applicant has is that the tribunal has to apply the law. And the law is set out in the Act, and it is set out in the regulations, and it is set out in the guidelines, because the guidelines and the regulations all have the force of law having been made under the relevant sections of the Act. The logical result of the applicant's submission, if it is correct, produces a bizarre outcome. Why? Because what the applicant would have you do is look simply at the RFQ itself. Examine that. Stay within the four corners of that. To what the procuring entity has to do, because remember, in this challenge, it is not the applicant's conduct which is being challenged. It is the procuring entity's conduct that is being challenged. And what the procuring entity has to do is act in accordance with the regulations and the guidelines. If the applicant's invitation to this panel is correct, look at the RFQ alone. What you will have is a schism. And the schism will be that the procuring entity has to act in accordance with a procedural regime on the one hand, but on the other hand, the RFQ must be evaluated within narrow boundaries. And with respect, that can't make any sense. It would create a conundrum that every procuring entity would find itself in a RFQ process. With respect, unacceptable, and we say illogical conundrum. Because this is what binds the procuring entity. The regulations and the guidelines and the Act, they all bind the procuring entity. Oh, I think it is very helpful for me to try to take the panel to treat with some fairly elementary, what on the surface may appear to be fairly elementary questions. But they are nonetheless, in my respectful view, helpful. What is an RFQ? What is an RFQ? Well, we are told within the regulations, guidelines, and the Act. In summary, an RFQ is a process that is intended to be used for relatively readily available goods and services, which in this case we say diesel is readily available, and the service is readily available, which is transport. Because this is an RFQ, let's make no bones about it. This is an RFQ about transporting diesel from one point to another and refueling a vessel. That's what it's about. It is not about procuring nuclear arsenal. It is not about procuring some hugely technical computer hardware. This is a straightforward RFQ. And what you will see is that the guidelines and the act demonstrate that the RFQ is supposed to be quick. It's to require the use of minimal resources and standard form documents for the procuring entity. And it is aimed at securing the lowest possible price for that entity. That is what the process is about. Now, there's no complaint in this case that the wrong process has been used. The applicant accepts the process. Now, what underpins or what makes good these submissions as to what the RFQ process is? Well, we say, and I don't intend to take the panel to it, but I ask you to take a note of it. We say Regulation 10 makes good the proposition. Regulation 10 of the Procurement Methods and Procedures under the heading Request for Quotations. That is a specific. It would be difficult not to see it if one had regard to the regulations. That is a specific regulation which has been carved out to facilitate the request for quotation procedures. Perhaps now may be a convenient time for those that support the panel to bring up the document on the screen. Yes. I have 1 minute. What you will see in Regulation 10 itself is that if we start with 10, 2 lines down, it says it's to be utilized for readily available, relatively low price goods and services, which are not specially produced, so provided to the particular specifications of the procuring entity, and for which there is an established market. And 11 says where request for quotations is to be utilized, a procuring entity shall, using standard documents it's prepared, request quotations in writing from as many suppliers or contractors as practical, but not less than 3 suppliers or contractors. Emphasize use of standard documents because there's a point to be made about that, to which I will come. And then it also provides that those use of standard documents are mandatory. The procuring entity shall use them. And then at 11.3, a written request for quotations shall contain a clear statement of the procuring entity's requirements with respect to quality, quantity, terms, and time of delivery of the subject procurement. Note carefully, the request for quotations does not set out or does not make any reference to a scoring or weighting criteria. Now, the use of standard documents, the legislative choice to utilize standard documents is not an accident. It is to provide agility and to facilitate quickness in procuring goods and services. That means, we respectfully submit, that when you come to consider the RFQ itself, the panel ought not to consider it in a microscopic way. It needs to understand contextually that an entity going out on an RFQ process is required to use its standard document, and therefore that there must be some flexibility, accommodation, and understanding that Parliament does not permit the entity to move outside the standard terms of the document. That's the first point that we make about that. Now, insofar as the methods and procedures guidelines are concerned, that document is also helpful in understanding what the RFQ is. Paragraphs 3.1, 3, and 7.2 are instructive. If one looks at 7.23d, it says in terms that the successful quotation shall be the lowest price quotation, meeting the needs of the procuring entity as set out in the RFQ. So this is obviously an important consideration when one comes to consider the RFQ document itself, and what parties engaging in this process must understand to be the nature of the process and the requirements of the process. An applicant cannot put itself in an ivory tower and blindly close its eyes and say, I do not know what the regulations require. I do not know what the act requires. I'm entitled to ignore all of those things and look purely within the four corners of the RFQ. With respect, that would be reckless. It would be absurd, because what the cases say, and we've cited them, they're in our written submissions, and we rest upon them, is that the cases consistently speak about the reasonably informed tenderer. A tenderer needs to inform itself. And the process of informing oneself requires a tenderer to acquaint itself with the provisions of the Act and the regulations. Of course, very interesting, one of the authorities relied upon by the applicant here is a text called Public Procurement Principles, Categories, and Methods. It's a text by George Lynch. So we consider this to be quite helpful. It's at Rahamut's tab 1 of their submissions. That's what the text is referred to. But we say that although they helpfully refer the tribunal to the text, they omitted a particularly relevant part of the text, no doubt inadvertently. And we have taken the liberty of annexing that to our reply submissions filed today in order to assist the tribunal. It is tab 7. And what the tribunal will see there is very consistent with the approach NIDCO took in this case. It is the last paragraph, it's the penultimate paragraph under the heading Request for Quotations. Don't know if the tribunal has been able to locate it. Tab 7, as if we go down a page, one more. Yes. If we go up just above advantages, we'll go up a bit more, right? If we can stop right there. The paragraph beginning. Quotations received in response to a request for quotations should be evaluated for compliance with the technical specifications or scope of work of the requirement and the administrative requirements of the request for quotations. only after determining administrative and technical compliance is a price comparison made between compliant firms, and then a purchase order is signed with the firm, and it goes on. The point to be made there is that it is well recognized industry-wide that when you are looking at an RFQ process, one determines technical requirements and then proceeds to go on to price. And of course, it makes sense, because if you can't satisfy the technical requirements, it makes absolutely no sense to go on to consider the price. So it is a perfectly logical and sensible process for a procuring entity to examine technical requirements first and then move to consider the question of price. Now, if we can move to another aspect of submissions, and it is this question: what was NIDCO supposed to do in the evaluation process? What was NIDCO supposed to do? This document can be taken down from the screen if it is helpful. Well, the evaluation regulations help us in that regard. Regulation 3, excuse me one moment. I'm sorry about that. Regulation 3 of the evaluation regulations, perhaps that can be brought up for us. This is the EVA. This can be found Regulation 3. Yes, it's on this. No. If I can go to 3.1. Yes, I'm sorry, I'm now seeing it. A procuring entity provides a procuring entity shall, and it's mandatory, select a successful submission based on evaluation criteria and methodology specified in its bidding document. 3.3 says an evaluation criterion may refer to both price and non-price factors. Regulation 5 is equally important. We go down the page. 5.1 says a procuring entity may identify in its bidding document, in addition to the price factor, a relevant non-price factor. What is a non-price factor? And we submit that when one looks at the regulation, a non-price factor is given a very specific legislative meaning. And we are told what a non-price factor is under Regulation 5.2. A non-price factor refers to a factor which is not monetarily quantifiable and is assessed using a scoring or weighting system. So what we say here is that in the RFQ document, we say that there is plainly no scoring or weighting system included in that document. And accordingly, all of the factors which are considered in that document do not qualify as non-price factors within the meaning of Regulation 5 of the evaluation regulations. And it is important, with respect, we say it is an important distinction that the tribunal has to appreciate. And it is also a distinction which is supported by logic as well. Because broadly speaking, you could have non-price factors which do not lend themselves to any scoring or weighting system. Take, for example, availability. If I am a procuring entity and I am going out today to procure for envelopes, availability is a non-price factor, but I can't weight it or I can't score it. One either has the product or they don't have it. So we say that the legislature would have made a definite choice and they would have given a procuring entity the freedom to say, you can have price, you can have price factors with a weight.
Mr. Mutu, apologies, we are having a technical issue on our end and we would like to ask for a pause, please.
Of course.
Thank you. Thank you, Mr. Mutu and other participants. We were having a problem with the YouTube feed, so that would have been the genesis of the technical issue. Rest assured that the contributions of the parties are all appropriately recorded and we did not miss anything. Mr. Mutu, you may continue and you would be given lost time. You have approximately 15 minutes remaining. You may proceed.
Thank you. I'm not entirely sure I'm going to complete my submissions within that time frame, given the importance of these matters, but I will try. I had just looked at Regulation 5 with a view to demonstrating that you could have a non-price factor, which would not be assigned a scoring or weighting criteria. And I have made reference to availability. So I emphasize the point that it is critical to note that when we look back at Regulation 11, which I referred to, there is no mandatory requirement for a procuring entity to use a weighting or scoring system. We submit that the procuring entity has a choice to make with respect to the criteria. It will, other than price, and it can use a mandatory requirement. The evaluation guidelines make this abundantly clear. In the interest of time, I don't propose to, well, it's 3.2 of the evaluation criteria. What you will see under the evaluation guidelines of paragraph 3.2. The second paragraph is that, yes, the procuring entity is given a choice. And the way in which it is framed is as follows. Once the basic evaluation criteria identified for a procurement activity, the procuring entity must decide which criteria will be mandatory and which will be weighted. So it has a choice to make. And if we look under the table mandatory criteria, we will see at the first bullet point, mandatory criteria establishes the basic requirements of the invitation. We say the RFQ here satisfies that, and I'm going to come to that next. And then at the end, the last sentence on the second bullet point, a point system is not used. So what this document recognizes, not even implicitly, but expressly, is you could choose mandatory criteria as opposed to a scoring system. And you don't have to use a point system. And then it says, if we go down a bit, the procuring entity, we move down a little bit again. Yes, if we can stop there. Just above the heading note, the procuring entity shall select a successful supplier or contractor based only on the evaluation criteria and methodology specified in detail in the solicitation documents. And Mr. Garcia had regard to that, right? And I'm going to take you to that now because that is what we did here. And if I could ask the panel to respectfully turn up the request for quotations in this case. Yes, if we can stay right there on the first page. Now, turning to the facts, we say it is completely wrong for the applicant to assert, for the reasons we've pointed out, that NIDCO was supposed to apply a scoring system or weighting criteria to the bids received by it. Now, looking at the RFQ itself, there's several points to be made here. You will see on the first page of the RFQ, and we don't run from this, NIDCO set out the evaluation criteria for the RFQ as quality, price, and availability. Now, that is not by accident, because under Regulation 11 of the Public Procurement and Disposal of Public Property Regulations. Section 11.3 A provides that a written request for quotations shall contain a clear statement of the procuring entity's requirements with respect to quality, quantity, and terms. So if we can move down a bit on the page, we will see there at the third arrow or the fourth arrow, it says quotations will be evaluated at the sole discretion of NIDCO based on quality, price, and availability. I think we've gone way down. Go back up to the first page of the RFQ. It's the fourth arrow at the foot. Yes. Now, importantly, NIDCO never said in this RFQ that it was going to apply a scoring or weighting system to any evaluation criteria. And they didn't. So that the tenderer here, Rahamut, could not have been under any misapprehension or doubt as to what was going to happen. They knew no scoring or weighting system was going to be applied. That's the first point. The second point is that NIDCO was entitled to treat, we say, with the evaluation criteria on a pass-fail basis, which, to use the language of paragraph 3 of the 3.2 of the evaluation guidelines, is to treat it as mandatory. Either meet it or you don't. Pass or you fail. And NIDCO had to select the successful tender submission based on it. Now let's look at the document and let's see the language that NIDCO actually uses. If we go to page 2, under the technical requirements, here, this is, yes. And let's look at the technical requirements. Now my submission is when you look at the technical requirements, what NIDCO is saying by this document is you either meet it or you don't. No scoring, no weighting. This is really pass or fail. Technical requirement 1, tenderers must own, language is mandatory, and maintain road tank wagons. Requirement 2, tenderers must possess valid permit to operate. Requirement 3, tenderers must include their quality control. 4, provision of suitably certified road tank wagons of 50,000 litre capacity. Well, we'll come to that point in a minute. Requirement 6, tenderers must possess a valid peddler's license. Requirement 7, tenders must be approved by the Ministry of Energy and Energy Affairs. And of course, all of this is self-evident. In order to transport fuel from point A to point B and pump the fuel, these are mandatory requirements. This is not rocket science. Any tenderer receiving this document, what are they going to say? How could it sensibly operate in the mind of any reasonably informed tenderer that somehow these requirements weren't mandatory? They can't provide the service which NIDCO is asking them to provide, i.e., transport fuel and pump it without these requirements being met. It is self-evident that they are mandatory. The document doesn't have to use the word mandatory. There's no magic in that word. One must understand that the requirements are mandatory because you can't provide the service without these things. The use of the word must makes it clear. And if more is required, the word requirement. If it is a requirement, it logically follows it is mandatory. So the point that the applicant tries to make that somehow the applicant didn't know that these requirements were secret. It couldn't know if it was mandatory. With respect, that is a hollow argument. Anyone reading this document must know it is mandatory. Anyone like the applicant engaged in the transportation of fuel from point A to point B must know these requirements are mandatory. But it doesn't stop there. We need to turn the page. Requirement 8, tenderers must provide. Requirement 9, tenderers must submit. Requirement 10, all bidders must provide. Requirement 11, copies of certification for the company's on-site storage tanks. Requirement 12, tenderers must provide. Requirement 14, tenderers are required. We can go further down the page again to the technical requirements in relation to Galleon's passage. But in the interest of time, I don't intend to go there because these requirements are essentially a repeat of the requirements I've just pointed out. And if we go to the penultimate page of the RFQ itself, it may be convenient to just point out here under the heading Request for Clarification. If we can move down a few pages on the document. Yes, at the top of that page, Request for Clarification, it says, tenderers are required to email their questions on matters on which clarifications are needed. The point we make here is a fairly straightforward one. If the applicant was in any doubt as to what anything meant, it could have availed itself of these clarifications. It could have said to NIDCO, we don't understand what this means. Of course, NIDCO's position is it's in plain English. It's must. You can't offer the service without these requirements. But if you have any doubt, write to us. Avail yourselves of the opportunity. The applicant did not do so. Now, the applicant says quality, right? It didn't know what was required with respect to quality. We say the RFQ unquestionably satisfied this criteria. What is the quality? The services which were to be solicited were the services in connection with the transportation and pumping of fuel. To provide the service, you need a road tank wagon that is appropriately equipped. It is therefore blindingly obvious that the quality must be a reference to the quality of the road tank wagon and its ability to transport and pump the fuel. How is that quality satisfied? It's satisfied by the appropriate certifications being requested in the RFQ. It's all set out there. There's no magic about this. This is a simple contract to move fuel from point A to point B. Technical requirement 1 says the road tank wagons have to be appropriately filled with suitable apparatus and maintained. That goes to quality. Requirement 4 says the tenderers must have suitably certified road tank wagons for transferring diesel fuel from truck to the vessel. Requirement 4 says the tenderers must have suitably certified road tank wagons. It's all there. The quality is there. And NIDCO assess those requirements on a pass-fail basis. I don't want to take the tribunal take now in the interest of time, but if the tribunal takes the time to look at the CAT reporting transcript, there can be no dispute that NIDCO did this, and they said that they did it. I'm just going to give the tribunal the references, and the tribunal can look at this in due course. Page 92 of the transcript, lines 17 to 23. Page 101 of the transcript, lines 13 to 22. Page 107 of the transcript, lines 3 to 5. Page 111 of the transcript, lines 10 to 18. And what NIDCO says there repeatedly is that we looked at these requirements on a mandatory basis. We were satisfied that the requirements were met. And that was in accordance with exactly what it said it would do in the RFQ. That is precisely what it said it would do. And that is precisely what it was allowed to do under the evaluation guidelines 3.2. And more importantly, what it was obliged to do under regulation 3.1, because it could only select based on the evaluation criteria and methodology specified in the bidding document. Now, there is a small point that should be made here for completeness, is that insofar as one looks at regulation 5, which we looked at earlier, which dealt with non-price factors. Regulation 5.3 of the evaluation regulations. I should have made this point earlier, but I didn't. And I apologize for not doing so. But there is this point to be made if we can turn the page. No, I'm sorry, you're on it. It says a non-price factor includes but is not limited to the quality of methodology and work plan. So when the legislature uses the word quality there, it is not quality of the service, right? It is quality in a different sense. And when one looks at the RFQ, no methodology or work plan was solicited by NIDCO from the bidders. They were invited to submit their best competitive quote and to fill out the BOQ as provided. Blank BOQ simply required them to fill in the numbers, the unit costs, and the total cost of transport. I've already dealt with the question.
Mr. Mutu?
Yes?
Mr. Mutu? Just a point to note, your time has elapsed. However, you may have 10 minutes to wrap up.
I'm much obliged, Chairman. If I could move quickly in the interest of time to a theme, and I have touched on this, that the applicant seems to harp on about, that the evaluation and selection criteria must be clearly stated in the solicitation documents. And it refers to regulations 24.1F and 25 of the evaluation regulations. We don't dispute as a general principle that this must be correct. But these principles cannot be applied out of context, nor can they be cherry-picked. So we say when you look at it, you have to look at it within the suite of all of the documents, within the context of the RFQ read as a whole. You can't pick out one line and insulate yourself from what all of the regulatory requirements say. Rahamut relies heavily on the UN Practitioners Handbook in their submissions. But we say that that handbook is a handbook that deals with UN organizations. That handbook cannot displace, it cannot supplant, it cannot override our legislation, our act, our regulations, our guidelines, which have statutory force. The very nature of the RFQ signals clearly to bidders that the focus of the tender process, including evaluation, is price. in the context of meeting certain mandatory requirements. We emphasize that. We can't say it too much. Requirements were mandatory. Tells bidders satisfy these requirements and quote your price. The word price is used collectively 8 times in the RFQ. The quotation, a request for quotation. What is a quotation? A quotation is a request for price. No reasonably informed tenderer could be under any misapprehension that what the RFQ document was asking it to do is to submit a price and meet these requirements. Nobody is telling you you're going to be scored. Now, to the extent that the applicant also relies on regulations 24.1 and 25 of the methods and procedure regulation, we make this separate point that these are all general provisions. They have to be subordinate to, and they cannot override regulations 10 and 11 or paragraph 7.2 of the methods and procedures guidelines, because these are bespoke provisions. These are the provisions that Parliament and the legislature and the regulator and the Office of Procurement have said, look, when you're coming to deal with an RFQ, this is what you look at. This is what you ought to be guided by. This is what is to govern. And this is what NIDCO adhered to. There is no question at all in our respectful submission that it can be said that NIDCO as a procuring entity departed from any principle of fairness. We don't dispute that an implied contract arises at the tender stage. Nobody takes an issue with that. But what is fair, as I said earlier on, depends on what one is required to do in accordance with the regulations and the guidelines and the Act and the RFQ. It is unfair if you do something different. But NIDCO did exactly that which it was required to do. The applicant relies on an Ontario envoy relocation case. We distinguish that case for 5 reasons in our written submissions in reply, and we rely on that. And if I could move finally now to what is the alleged breach of this technical requirement as to road tank wells. We cite an authority, or we cite a couple of authorities dealing with context and how one construes documents. We rely on them because we say, and we repeat, you have to look at the documents as a whole. One cannot, on a proper construction of the RFQ, come to the conclusion that what was required was that a road tank wagon with a 50,000 liter capacity was a requirement. What one has to remember here, and this makes the point, NIDCO was not going out to procure for road tank wagons. They were procuring diesel. And therefore, how you got it there was a matter for you, provided you had the appropriate equipment to get it there. And it is clear, crystal clear, we say there's no ambiguity. When you read the request for quotation as a whole, what emerges is that you can use multiple road tank wagons to meet the actual capacity, the fuel capacity of what is required. Even the vessels themselves, the vessels had a capacity of a maximum of 30,000 liters, not 50,000. So on a plain reading of the words used, we say there was no specification that a tenderer was required to have a single or more than one road tank wagon with an individual capacity. We also make this point. We cited the case of Dendron Resource Surveys Incorporated in our submissions. And that's an important authority. We ask the tribunal to look at it in due course. Because what that says, the principle which emerges from that case, is that the evaluator, NIDCO, must be accorded a certain level of deference. It is not for Rahamut or, with respect, the panel to rewrite the technical requirements of the RFQ and impose its view on what NIDCO ought to have required. And the principle emerging from Dendron is supported by the Saskatchewan case cited by the applicant as well. So this is a consistent line of authority. We make this final point on this topic, that the post-bid clarification document solicited from the tenderers does not amplify the requirements of the RFQ. Nor could it. Mr. Garcia took you to those documents. But those responses were responses in order to clarify the bids of the bidders. It wasn't NIDCO providing a document to clarify what it required. It was saying to the bidder, you clarify for me what you have submitted. So in the circumstances, we invite the panel to dismiss Rahamut's challenge. In fact, we submit to uphold it would have far-reaching and unintended consequences. It would run counter to the philosophy behind the request for quotation process. It would convert the process into an unduly technical, bureaucratic exercise, which would frustrate the quick provision of services. That's not what an RFQ process was intended to be. And most importantly, it would allow the highest, not the lowest bidder, to walk away with the contract 17% more than the lowest price. In those circumstances, we ask that the tribunal, the panel, also award us costs under section 50(10)H of its hearing rules, of the Act, forgive me, which allows it to take such other action as is appropriate in the circumstances. And we say that is a broad provision which allows the tribunal to award NIDCO costs if they were successful. If it were otherwise, we would then have a legislative scheme which does not recognize equality before the law and which promotes inequality of treatment. The broad powers given to the panel under the Act, under section 50(10)H, we say, allows NIDCO to recover its costs in the event that it successfully defends this challenge. Unless I can be of any further assistance to the panel, those are our respectful submissions. And thank you for the additional time.
Thank you for your submission, Mr. Mutu. The panel will take a short break and then we would continue.
Thank you, sir.
Thank you, applicant, and thank you, respondent, for your submissions. And having heard both oral closing statements for both sides, the presentation of the cases of both parties are now closed. In keeping with the order dated the 28th of May 2024, the parties can submit their closing submissions by the 10th of June 2024, addressing the following: matters arising from the oral closing submissions today. The applicant addressed matters contained in the respondent's reply submissions filed today, the documentation that would have been filed today. The respondent to address the applicant's application for course form 15, and both parties to address the respondent's request for costs pursuant to 5510H.
Very grateful, sir. Much obliged.
The decision will be provided to parties on the 14th of June 2024 by the hearing secretary, and written reasons will be provided in keeping with the statutory time frame. The panel would like to thank all of the parties, the representatives, and all who are here today in these proceedings. It is indeed groundbreaking, as was mentioned by one of the participants earlier today. And in terms of next steps, I already mentioned that we would be given the decision on the 14th of June in accordance with section 5011, and reminder of the written reasons. The written reasons will be statutorily due 30 days after the panel's decision is given in accordance with section 5012 of the PPDPA. However, we would endeavor to provide the same within or before the expiration of that period, and it will be issued by way of email through the hearing secretary. So once again, thank you everyone for participating today, and have a great day.
Thank you, sir. Same to you.
Thank you. Enjoy the weekend.
You too.
You too.